The Constitution of the Commonwealth of Puerto Rico is the controlling government document of Puerto Rico. It is composed of 9 articles detailing the structure of the government as well as the function of several of its institutions. The document also contains an extensive and specific Bill of Rights. Since Puerto Rico is a Commonwealth of the United States, the Puerto Rico Constitution is bound to adhere to the postulates of the U.S. Constitution due to the Supremacy Clause, and of relevant federal legislation due to the Territorial Clause. It was ratified by Puerto Rico's electorate in a referendum on March 3, 1952, and on July 25, 1952, Governor Luis Munoz Marin proclaimed that the Constitution was in effect. July 25, which had been an official holiday in Puerto Rico commemorating the invasion of United States troops in Puerto Rico on July 25, 1898, is now known as Constitution Day. According to University of Puerto Rico law professor Antonio Fernández López Cepero, Munoz Marin chose July 25 for the proclamation of the Constitution with the intention of replacing the 1898 commemoration with the commemoration of the adoption of the Constitution. In an article published on July 25, 2010, the late Professor Fernández López Cepero stated to El Nuevo Dia newspaper that he heard this information from his father, the late Dr. Antonio Fernández, who was the president of the Constitutional Convention in 1952. History. It was ratified by Puerto Rico's electorate in a referendum on March 3, 1952. The United States Congress and the President approved it by Pub. L. 82-447, 66 Stat. 327, enacted July 3, 1952, requiring that the Bill of Rights Section 20 be stricken and that language be added to Section 3 of Article 7. On July 10, 1952, the Constitutional Convention of Puerto Rico reconvened and approved a resolution accepting the conditions established by Pub. L. 82-447, which were later ratified in a referendum held in November 1952 by the electorate. On July 25, 1952, Governor Luis Munoz Marin proclaimed that the Constitution was in effect. In a speech on July 25, 2013, Governor Alejandro Garcia Padilla, despite the conditions established in Pub. L. 82-447, proclaimed that, henceforth, Sec. 20 would be deemed by his administration to be in effect. The United States government authorized Puerto Rico to draft its own constitution by Pub. L. 81-664 Stat. 319, enacted July 3, 1950. The Constitutional Assembly met for a period of several months between 1951 and 1952 in which the document was written. The framers had to follow only 2 basic requirements established under Pub. L. 81-600. The first was the document must establish a republican form of government for the island. The second was the inclusion of a Bill of Rights. The Constitution was approved overwhelmingly by nearly 82% of the voters in a popular referendum and ratified by the United States Congress with a few amendments. The United States maintains ultimate sovereignty over Puerto Rico while giving Puerto Ricans a high degree of autonomy. Under this constitution, Puerto Rico officially identifies as the Commonwealth of Puerto Rico. A continuing debate has dealt with the legal status of Puerto Rico under the federal government of the United States. Certain decisions by the Supreme Court of the United States appear to have interpreted the Territorial Clause of the United States Constitution as still controlling over Puerto Rico. Under this clause, the United States Congress is the recognized sovereign of the island. In 1976, the U.S. Supreme Court clarified that the purpose of Congress in the 1950 and 1952 legislation was to accord to Puerto Rico the degree of autonomy and independence normally associated with the State of the Union. However, on June 9, 2016, as an outcome of the case known as Puerto Rico v. Sanchez-Vail, the U.S. Supreme Court incited a debate regarding the nature of the relationship established by the 1950 and 1952 legislation, allegedly breaching the compact between the United States and the people of Puerto Rico. The debate was fueled when the Supreme Court decided that the Double Jeopardy Clause bars Puerto Rico and the United States from successively prosecuting a single person for the same conduct under equivalent criminal laws. The Supreme Court ruling stated that, at least in the cases related to criminal offenses, sovereignty of Puerto Rico ultimately resides in the United States Congress. The argument made by the U.S. Supreme Court was interpreted by many as an affirmation of a severely diminished capacity of the constitutional stature that the Puerto Rican government had, the same idea of stature that the Puerto Rican government has had for nearly 7 decades. Although Judge Elaine Keegan stated that the ruling in the case of Puerto Rico v. Sanchez-Vail was confined solely to the corresponding issue of double jeopardy within a criminal case, not to the whole of Puerto Rico's political status. Still, the outcome fueled a debate regarding the current nature of the political relationship established between Puerto Rico and United States of America. Founding Fathers. 12 weeks after the people of Puerto Rico approved to write their own constitution in a referendum, 92 individuals were elected as delegates to a constitutional assembly on August 27, 1951. Of these, 70 belonged to the Popular Democratic Party, 15 belonged to the Republican Statehood Party, while 7 belonged to the Puerto Rican Socialist Party. Members from the Puerto Rican Independence Party abstained from participating. The following is a list of the delegates. The delegates, which would eventually become the founding fathers of the current Commonwealth of Puerto Rico, established 10 permanent committees, 7 which dealt with constitutional matters and 3 which dealt with the Assembly's internal operations. The constitutional committees were as follows. The Assembly held 62 sessions between September 17, 1951 and February 6, 1952, approving the Constitution within the Assembly 2 days before concluding their affairs on February 4, 1952. The Constitution was then overwhelmingly approved a month later by the people of Puerto Rico in a referendum held on March 3, 1952. Preamble. The preamble reads, "We, the people of Puerto Rico, in order to organize ourselves politically on a fully democratic basis, to promote the general welfare, and to secure for ourselves and our posterity the complete enjoyment of human rights, placing our trust in Almighty God, do ordain and establish this Constitution for the Commonwealth which, in the exercise of our natural rights, we now create within our union with the United States of America. In so doing, we declare, the democratic system is fundamental to the life of the Puerto Rican community. We understand that the democratic system of government is one in which the will of the people is the source of public power. The political order is subordinate to the rights of man, and the free participation of the citizen in collective decisions is assured. We consider as determining factors in our life our citizenship of the United United States of America and our aspiration continually to enrich our democratic heritage in the individual and collective enjoyment of its rights and privileges, our loyalty to the principles of the federal Constitution, the coexistence in Puerto Rico of the two great cultures of the American hemisphere, our fervor for education, our faith in justice, our devotion to the courageous, industrious, and peaceful way of life, our fidelity to individual human values above and beyond social position, racial differences, and economic interests, and our hope for a better world based on these principles. The preamble of the Constitution of Puerto Rico is more extensive than the preamble to the United States Constitution. However, it has the similarity that the preamble neither grants any powers nor inhibits any actions. It only explains the rationale behind the Constitution, yet it specifically details the determining factors that the Puerto Rican people have chosen as the basis for the new government. It also establishes the Constitution's loyalty to the principles of the federal Constitution. Articles of the Constitution. The remainder of the document consists of 9 articles. Article 1. The Commonwealth. Article 1 establishes the new government for the island, which shall bear the name of Commonwealth of Puerto Rico. It declares that the source of the power of the government emanates from the people. The following 3 sections of the article establish the republican form of government of the island, divided into 3 branches, and specifies the territorial jurisdiction of the document as well as the seat of the new government, which shall be the city of San Juan. Article 2. Bill of Rights. Article 2 of the Constitution is known as the Bill of Rights of Puerto Rico. In order to comply with the requirements of Public Law 600, the framers of the Puerto Rican Constitution decided to draft an extensive list of rights which were then organized into a whole article of the constitutional document. It is divided into 19 sections, each one listing one or several rights which are deemed fundamental under Puerto Rican constitutional law. Section 1 begins by establishing that the dignity of the human being is inviolable and that all men are equal before the law. These 2 sentences have traditionally been interpreted by scholars as granting an unlimited amount of rights, since anything that violates the dignity of a human being will be deemed unconstitutional. However, the remainder of the section concretely establishes the kinds of discriminations that are outlawed. No discrimination shall be made on account of race, color, sex, birth, social origin, a condition, or political or religious ideas. Both the laws and the system of public education shall embody these principles of essential human equality. Section 2 establishes the right to vote in Puerto Rico. Section 2. The laws shall guarantee the expression of the will of the people by means of equal, direct and secret universal suffrage, and shall protect the citizen against any coercion in the exercise of the electoral franchise. Section 3 is the religious clause of the Puerto Rican Constitution. It prohibits the establishment of religion and protects the free exercise of religion. It reads, "No law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. There shall be complete separation of church and state." The last sentence specifically and concretely establishes the separation of church and state, a clause that is not found in the United States' Constitution, but rather it is assumed and interpreted to exist. Section 3 leaves no doubt about the existence of such separation in Puerto Rico. Section 4 is very similar to the First Amendment to the United States Constitution. It establishes the freedom of speech, freedom of the press, freedom of assembly, and the right to petition. It reads, "No law shall be made abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances." Section 5 establishes the right to an education. It also mandates the the establishment of a non-sectarian and free educational system for the island. The section also establishes that education will be compulsory for elementary school, to the extent permitted by the facilities of the state. The section further establishes that no public property or public funds shall be used for the support of schools or educational institutions other than those of the state. Section 6 declares the right of the people to organize themselves in associations, except if the associations are military or quasi-military in nature. Section 7 contains several important fundamental rights. It reads, "The right to life, liberty, and the enjoyment of property is recognized as a fundamental right of man. The death penalty shall not exist. No person shall be deprived of his liberty or property without due process of law. No person in Puerto Rico shall be denied the equal protection of the laws. No laws impairing the obligation of contracts shall be enacted. A minimum amount of property and possessions shall be exempt from attachment as provided by law." First, Section 7 establishes that the right to life is fundamental in Puerto Rico. Because of this, the section determines that the death penalty will not exist under the jurisdiction of the Commonwealth. Second, the section contains the due process of law as well as the equal protection clauses. Third, it includes a contract clause for the jurisdiction of the Commonwealth. Finally, the sections guarantees that a minimum amount of the property owned by individuals will be exempt from government possession. Section 8 declares that every person has the right to be protected by law against attacks on his honor, reputation, and private or family life. This section has been interpreted as creating a general right to privacy in Puerto Rico. Section 9 creates more liberties for the press. It establishes that no law shall be enacted authorizing condemnation of printing presses, machinery, or material devoted to publications of any kind. The buildings in which these objects are located may be condemned only after a judicial finding of public convenience and necessity pursuant to procedure that shall be provided by law, and may be taken before such a judicial finding only when there is placed at the disposition of the publication an adequate site in which it can be installed and continue to operate for a reasonable time. Section 10 is similar to the Fourth Amendment to the United States Constitution. It establishes that persons shall be protected against unreasonable searches and seizures. It explicitly prohibits the use of wiretapping. Furthermore, it declares that no search warrant shall be issued unless probable cause is shown. Section 11 is primarily devoted to the rights of the accused. In all criminal prosecutions, the accused shall enjoy the right to have a speedy and public trial, to be informed of the nature and cause of the accusation and to have a copy thereof, to be confronted with the witnesses against him, to have assistance of counsel, and to be presumed innocent. It also establishes that in all trials of felony the accused shall enjoy of a jury of 12 peers who render a verdict by majority vote in which no less than 9 shall concur. Also, the section creates the right against self-incrimination as well as the prohibition of double jeopardy. Section 12 outlaws slavery and involuntary servitude unless duly convicted. It also prohibits ex post facto laws and bills of attainder. Section 13 guarantees the writ of habeas corpus, which can only be suspended by the Legislative Assembly in time of rebellion, insurrection, or invasion. Section 14 prohibits the use of titles of nobility. It also prohibits public officials to receive gifts from foreign powers without the approval of the Legislative Assembly. Section 15 deals with child labor. It prohibits the employment of children of less than 14 years on jobs that may be prejudicial to the health or morals. It also guarantees that no children under the age of 16 shall be kept in jail. Section 17 creates the fundamental right of employees, private and public, to organize themselves into associations and to negotiate with their employers. Section 18 also declares a fundamental right for employers to go on strike. However, the section ends by stating, "Nothing herein contained shall impair the authority of the Legislative Assembly to enact laws to deal with grave emergencies that clearly imperil the public health of safety or essential public services." Section 19 is similar to the 9th Amendment to the United States Constitution. It reads, "The foregoing enumeration of rights shall not be construed restrictively, nor does it contemplate the exclusion of other rights not specifically mentioned which belong to the people in a democracy. The power of the Legislative Assembly to enact laws for the protection of the life, health and general welfare of the people shall likewise not be construed restrictively." This section stresses out that the civil rights and liberties outlined in this Bill of Rights do not constitute an exclusive list thereof. Others may exist. In other words, just because a civil right is not listed here, does not mean that the people do not have it. This is a safeguard against strict literal interpretations of the Constitution with which the people will be denied all the rights not specifically listed here, such as the right to travel between districts at their own leisure, or the right to travel abroad. Article 3. Legislative Power. Article 3 establishes the legislative power in Puerto Rico, which is vested in a bicameral legislature that bears the name Legislative Assembly of Puerto Rico. The two houses that compose this assembly are the Senate, with 27 members, and the House of Representatives of 51 members. Article 4. Executive Power. Article 4 describes the powers, structure, functions, responsibilities, and legal scope of the Governor of Puerto Rico, the executive branch of the Government of Puerto Rico. The article establishes the term length of the Governor and the requirements to hold such post, as well as establishing the Governor as Commander-in-Chief of the militia, namely the Puerto Rico National Guard. It also establishes that the Governor must present a State of the State address to the Legislative Assembly each year, as well as a report on the budget of the Government of Puerto Rico. Article 5. Judicial Power. Article 5 describes the powers, structure, functions, responsibilities, and legal scope of the Supreme Court of Puerto Rico, the judicial branch of the Government of Puerto Rico. The article also establishes that the Supreme Court must be the court of last resort, and that it must be composed by a Chief Justice and several Associate Justices. It also establishes that judges must be appointed by the Governor of Puerto Rico with the advice and consent from the Senate of Puerto Rico. Article 6. General Provisions. Article 6 authorizes the Legislative Assembly to create, abolish, consolidate and reorganize municipalities, to change the territorial limits, to determine their organization and functions, and to authorize them to develop programs for the general welfare and to create any agencies necessary for that purpose. It also authorizes the Commonwealth of Puerto Rico to impose and collect taxes and to authorize their imposition and collection by municipalities, as determined by the Legislative Assembly. Article 7. Amendments to the Constitution. Article 7 established the rules to perform amendments to the Constitution. The Legislative Assembly may propose amendments to this Constitution by a concurrent resolution approved by not less than 2/3 of the total number of members of which each House is composed. All proposed amendments shall be submitted to the qualified electors in a special referendum, but if the concurrent resolution is approved by not less than 3/4 of the total number of members of which each House is composed, the Legislative Assembly may provide that the referendum shall be held at the same time as the next general election. Each proposed amendment shall be voted on separately, and not more than 3 proposed amendments may be submitted at the same referendum. Every proposed amendment shall specify the terms under which it shall take effect, and it shall become a part of this Constitution if it is ratified by a majority of the electors voting thereon. The Section 3 indicates that no amendment to this Constitution shall alter the republican form of government established by it or abolish its bill. If rights, by Resolution Number 34, approved by the Constitutional Convention and ratified in the referendum held on November 4, 1952. The following new sentence was added to Section 3 of Article 7. Any amendment or revision of this Constitution shall be consistent with the resolution enacted by the applicable provisions of the Constitution of the United States, with the Puerto Rican Federal Relations Act and with Public Law 681st Congress, adopted in the nature of a compact. Article 8. Senatorial and Representative Districts. Article 9.